Welcome to episode 2 of The Monitor. We're going to dig right in today and get busy. I have a special guest with me, my grandson Ezra. He's going to hang out, say hello. So, we have the Association of Supervised Ankle Monitoring Providers has worked with Louisiana State Representative Tim Kerner to introduce House Bill 244. House Bill 244 is the second installment in a Bail 2.0 reform package that the association has been working on to bring transparency and accountability to the criminal justice system as it relates to ankle monitoring and the digital jail process. Last year we passed what became Act 746, and the main piece of Act 746 was it made it possible to arrest a provider for failing to report serious violations, dead batteries, comm losses, victim violations, and strap tampers. These are some of the types of things that have been plaguing Louisiana and all across the state. In every city, people being killed by individuals wearing ankle monitors whose batteries have died or whose providers just don't watch them. A St. Francisville murder took place when a company was ordered to watch an individual in a domestic case. They provided victim protection, which basically stated that if the offender violated a certain zone of the victim, that the court and the jail and the sheriff and everybody else would be notified. For 5 days, this individual stalked his wife, including hiding in her closet. On the last day, he was there, and she came home and was unloading her car, and he was able to murder her, and in the process, shot her friend as well. He was subsequently found deceased in the home after committing suicide. It's a terrible story, but what made it worse was the provider basically lied to the district attorney's office, told the DA that they did their due diligence, and we were able to assist this district attorney in understanding the data, and it allowed the district attorney to seek and get an indictment against this provider. Ultimately, the First Circuit Court of Appeals tossed the charge, the case, because they said there was no law that mandated an ankle monitor provider had to watch people. That's what brought us into the state legislature last year and passed House Bill 874 that became Act 746. Interestingly, at the end of the session, the state Supreme Court reversed the First Circuit Court of Appeals and reinstituted the Bill of Information, the indictment against the provider, and that case is ongoing. The bill last year, the law that was passed, essentially brought an identity. It showed the community what a provider is. It explained the difference between a provider and a manufacturer. It created some laws that require providers to do their job, and if they fail to do so, they face jail time, a fine, and ban from the state for providing the service for 5 years. It also had some other interesting things in it that we wanted to clean up this year. The new bill goes a little farther. It requires a registry, an offender registry, which is very important. Everybody in the state needs to be able to know who's on ankle monitor, who's watching the ankle monitor, who ordered the ankle monitor, what are the conditions, and is everybody doing their job, the offender, the provider, and the judge. And even the equipment, is the equipment doing its job? So this new bill, House Bill 244, actually brings that to the front, and it forces this type of transparency. It also works to create an environment where the person doing the supervision no longer has deniability. One thing that Louisiana, the whole country, cannot afford is to have unaccountable third-party boondoggles running around putting ankle monitors on people with zero accountability. Every single person released basically on ankle monitor is released on some sort of crime that likely has a bond in place, and that surety under state law is responsible for the individual in their custody. Please forgive the birds. If you have an individual in your custody and you have an ankle monitor on them and they're violating the conditions of that ankle monitor release, then you have to be able to do something about it. Being some third-party guy that's just slinging bracelets with I notified the court, I sent an email, I sent a text. It's just not enough. You have to actually have skin in the game. You have to have a person at the other end of that ankle monitor that can interject immediately, especially in the case of victim protection. So the new bill does that. It requires that the surety, the person who is receiving the offender from jail, irregardless of the ankle monitor, you have either a commercial bail agent or a mom, a church, a bail fund, cash, personal surety. Each and every one of those types of releases come with requirements, and the requirements are to make sure the offender appears in court. You can go one step farther, then you can add conditions like stay away from victims, go to school, or stay home, or even more. And that person, that surety, they're responsible for that. They have to make sure that that person does that. Never in Louisiana have we ever enforced that. We've used these third-party ankle monitor providers, and there's nobody there to make sure these people behave. The ankle monitor provider needs to have skin in the game. They need to be involved. So House Bill 244 does that. It changes the statute, and it requires whoever the surety is to do one of two things: supervise these individuals or employ a licensed supervision program. So the state of Louisiana has a law that requires all sureties to have a bail license, and they are regulated by the Louisiana Department of Insurance. The enforcement mechanism is the Louisiana State Police, the Insurance Fraud Task Force specifically. This group of individuals are who make sure that bail agents are following the law. Putting a bail agent in charge of the release is not new. It's what they do now. They're in charge of the release. The bail agent simply ensures the appearance. What we say with House Bill 244 is that the surety will go one step farther and ensure performance. Now, if the surety wants to do it, they can do it themselves, or they can get a licensed entity to do it on their behalf. The licensing part is what's important. Making a person who is going to put an ankle monitor on aware of the state laws, aware of their responsibilities, aware of the constitutional rights of the individuals is very important, and you can't do that unless there's a classroom setting. Nobody in the ankle monitor industry today receives any type of training, and that is absolutely unacceptable. This is why we have issues with people who are violating individuals' rights or just not watching the ankle monitor at all. This law would change that, and it would mandate licensing in ankle monitors. It's very important. The industry itself has reached out to me and told me they don't like this rule, that they think it's unfair, that they don't want to be bail bondsmen. They're not bail bondsmen. They're enforcement teams. They're the enforcement entity for the release on ankle monitor. And if you don't want to enforce the ankle monitor you're installing, then you shouldn't be installing an ankle monitor in the first place. The other part of the law, it's a very important part, is when you have a surety who is uncooperative. Now understand, a surety under Louisiana law is who is responsible for the individual released to their custody. The surety could be the mom, it could be a bail bondsman, it could be a preacher, whoever does the bond, whoever signs the bond. That individual will now be compelled to be responsible. And if they don't do it themselves, they're going to have to get someone to do it on their behalf. It used to be if a person was released under a court order, the bail agent could just ignore the judge. If the judge says, look, they're not following the rules, please go get them, the bail agent can say, I don't help the police. The bail, and they've said that to us. The bail agent could say, I didn't make the order, the judge did, you do it. I understand the bail agent's position. They don't want to be the bad guy. They don't want to be accused by the offender of being the person that put them back in jail. It's not good for their business, if you understand what I'm saying. But this isn't what works to protect public safety. If you have an individual that's not doing what they're supposed to be doing and they're released to the custody of the bondsman, and the bondsman says, hey, I don't care what the court wants, I only have to make them go to court, well, then we don't have a perfect system. We have a system that is just running wild, and we need to stop that. So we have bail agents that refuse to cooperate with the court. This bill changes that. Upon affixing their signature on the bond, it would require them to either A, do this themselves, or B, employ someone to do it on their behalf. This is very important. We need to make sure that the digital jail process has continuity from the beginning to the end, that you don't get released to a bad bail agent or a bad industry that doesn't care about what happens in their community. They just care about their personal profits. So House Bill 244 is very important. House Bill 244 works to make sure that everybody in the criminal justice system is working together, that they're doing it the right way, and that there is transparency and accountability. A big part of the House Bill 244 is the creation of the offender management system, or an offender registry. And that offender registry is something that the association has already put out. It is available. It is free to the provider and to the public, to law enforcement. It's not about membership for individual monitoring programs. It's about the membership of our criminal justice community, judges, probation officers, prosecutors, police investigators, whoever it is in the wheel that needs information. They need to be able to easily look and see who is it that's on ankle monitor, who is it that's providing the ankle monitor supervision, what device are they on, who is the bail agent, what are the conditions of the release. Is the provider actually watching this individual? And is the judge doing anything about it when they are? This is all very important. This is the only way to make sure that every single person on monitor is actually being supervised, and that the people supervising them are actually doing their jobs, and that the judges are actually doing theirs. I don't like to always blame the judges because it's not always their fault. We don't have a jail space big enough to be the proper level of deterrence our community needs. We must have these digital jails, and it's good for our community. It's good to have a middle ground, a place between the brick and mortar jail and complete freedom, pre-trial, when your history and charges show that you could be a risk. This digital jail is like a filter system. It's like a strainer. It allows you to catch the people in the strainer that can be released pre-trial and safely live among us without causing more trouble. But it will also allow those who should fall through back to the jail to fall through. This is the easiest and fastest way to mitigate jail space without building a new jail. Ultimately, if you want to solve the problem, you need to build a new jail. I just don't think that's going to happen. We don't have the manpower, we don't have the funding, we don't have the will. So a digital jail is important. And in an environment where we're seeing growing numbers of digital jails, we're going to have regulations and legislation in place to make sure that the entities doing this are doing it right. And doing it in a way we can tell they're doing it right, not just they're telling us. I keep going back to the St. Francisville case, reading the newspaper article about the case and seeing that the DA was suffering trying to get an indictment. It bothered me. It was just his lack of understanding of how this process works, how the data works, how the data displays, how the communication with us goes, that allowed this guy, this DA, to not get this indictment, okay? So it's important that every person in the wheel is educated. And there's only one way to do that, and that's with complete transparency. That's why House Bill 244 is there. And our next legislative session next year, we're going to come again with more. We're going to add a little extra, because what we're trying to do is bring two entities, the bail entity and the ankle monitor entity, into the forefront together where they belong. You should not have a person released to bail through a surety with full arrest powers, and then at the same time released to some third party, especially a taxpayer-funded third party, put onto an ankle monitor, and those two entities don't talk. That bail agent has full arrest powers. That ankle monitor entity could, if they worked with that bail agent. The ankle monitor entity likes the path of least resistance. They want the money without the responsibility. The only risk in ankle monitors is arresting people, actually having to make them perform. That takes time, takes effort, and it's going to eat into your profits. But it will absolutely protect our community. It will absolutely bring transparency. It will absolutely bring accountability. So the idea that we're going to have an unaccountable third-party ankle monitor working completely isolated from the person who is responsible for the release just can't continue. So it's our goal to make sure that we educate our community in just that. Educate our community, both the public and the criminal justice system, and even those who are thinking of committing crimes. I want to thank you for tuning in again. Please watch us. We have a YouTube channel called Arrest Videos. You can find it on our Facebook page, the Association of Supervised Ankle Monitoring Providers. Our sponsor is the Assured Supervision Accountability Program, the single largest digital jail in the country, and it serves the state of Louisiana and surrounding states. We look forward to your input. If you have any questions, feel free to send us an email at gps@asapgps.org. asapgps.org is the website, and you can check out our association there. See you next time.